All right, guys. Chapter 7, the terms of a contract. As I said at the end of Chapter 6, contracts are never really that simple. There are a lot of detailed terms contained within any given contract. You'll see some of them given to you on the first two pages of this chapter, pages 140, 141, in the hypothetical contract between coasters and trackers, the same companies that we've been dealing with since Chapter 5. You'll see specifically paragraph 12 of their fictitious contract is warranties. Paragraph 13 is limitation of seller's liability. Paragraph 14 is exemption of seller's liability. Paragraph 20 is arguably the most boilerplate paragraph of any given contract, dealing with the entire contract itself. I've written contracts for a long time. Contracts are something that are not generally seen as being boilerplate. Now, again, if you have a services contract with a cell phone carrier, that is going to be boilerplate, and it's going to be written entirely in a fashion that favors the cell phone company. But generally speaking, if it's you owning a company or negotiating on behalf of a company with another company, the terms of any given contract are subject to intense negotiation, and they have to be detailed, and they have to effectively cover any contingency, any possibility. And the person who's actually, or the people who are actually drafting this contract, writing it, are going to have to take into consideration all possibilities, all eventualities. And you know what? As I probably stated at the very intro to this chapter, it's not easy. It's not easy to do that. All you can have in there are terms that hopefully will somewhat fit in and hopefully bring in to the contract the intent of all the parties. So we look specifically now at the content of a contract on page 141, and we see the terms, and we see that there can either be express terms or implied terms. Express terms, that's easy, guys. Is it written down directly in the contract? They are expressly stated in the terms of the contract. Again, we're talking mostly about written contracts. Oral contracts, it's generally difficult unless you have some type of audio recording device recording the entire thing. It's generally difficult to be able to say what the express contracts are of an oral agreement. Some people still like to get out there and do business based upon a handshake. That never really sits well with me as a lawyer. And it shouldn't sit well with anyone as a business owner. Times change. Relationships change. Getting something down in writing, even if you're doing business with a good friend, is a sensible move, because guess what? In the next month, 6 months, 12 months, 5 years, you may no longer be a friend, that person's friend. And you're going to want to have everything down in writing in order to protect you. Your interests. We also talk about the judicial interpretation of express terms, because even if you have express terms, they may be vague or ambiguous. And so judges are often called upon using rules of construction, that phrase you'll see mentioned on page 142, to actually provide some type of sane definition to a vague or ambiguous term. Implied terms are discussed on page 143. An implied term you'll see defined there as a provision that is not expressly included in a contract, but that is necessary to give effect to the party's intentions. You may not have it down, but it's implied within there. It's implied because rule of law would otherwise perhaps require it, or there is no other logical construction to the other provisions that are expressly included in a contract in order to be able to make it make logical sense. There's a good example here of this in the case note from page 143, the 911 emergency access. It's a case involving Bell Mobility Service and a guy named James Anderson and his son. For years, Bell was charging 75 cents. They were tacking it on to every bill to provide for a service, 911 emergency access. And when James Anderson finally needed it, he discovered that it was just simply a message that said there is no 911 911 emergency access in his jurisdiction, which I believe was Yellowknife. Yeah, Yellowknife. He sued. He sued as a matter of a class action on behalf of many people, as we've discussed in a previous chapter, saying that this is not right and that Bell owes its customers refunds for all the money that it put in over the years for an ineffective, non-existent 911 service. Bell said, listen, they can do that, they can charge for that because it's contained within their contract, and the contract essentially says even if there is no 911 service actually located in its jurisdiction. And Bell actually won before the trial court, before it actually lost before the appeals court. The appeals court said effectively that you can't charge for a benefit that is not received. The implied terms of the contract would appear to make it that if you're going to charge for a service, that service actually exists. Since there was no 911 emergency service apparently back then in the Yellowknife area, Bell had no right to charge its customers that 75-cent per month fee. The courts will rely on a variety of other methods in order to be able to figure out what constitutes the right interpretation of an implied term, what constitutes the existence of an implied term. There is business efficacy that you'll see listed on the bottom of page 144. There's also customs in the trade of the transaction. There are several industries where there is custom, it's custom driven, where this is how they have done business for decades or even centuries, and these customs are important for purposes of understanding whether or not there was an implied term to an agreement. You can also look to, or the court can also look to, previous dealings between the parties. This is the way we've always done it. So if we've always done it that way, then how could I not assume, arguably, that it's implied here that it's going to be done this way in this instance? And also, as I mentioned before, statutory requirements. You can't have, if there's going to be an implied term, and there's some law that's in existence, you can't necessarily say that that term doesn't exist, because under statute, under law, it has to exist. Or, if it's an implied term that would implicitly, seemingly, violate the law, then there's no way that the court can really ignore the implications behind interpreting the case one way as opposed to another way. You'll see noted on the top of page 148 this notion of quantum meruit. All right, so quantum meruit means reimbursement for not necessarily the entire contract price, but for whatever part of the contract was undelivered. You look at, so say that one party delivered on one half of the goods that or services that it promised. The person who has been wronged doesn't get the benefit of getting a full refund back on all of its services. Instead, the award from the court would be one based on quantum meruit. The design in damages is to put the person or the company back in the place that it would have been if the breach had never occurred to begin with. So you look at what's going to be required if you're out at least a section of what you were otherwise promised. You have to look at what the value of that is. You would be entitled to a refund for that particular part of the value, but also the court's going to look at, okay, how much more did the other company that's been wronged have to pay out in order to then get the benefit of the full service, maybe from another party. So, if I were to order 100 hamburgers from one particular restaurant, and I go there, and I've already prepaid for the hamburgers, and they say, well, we ran out of meat, we only have 50 hamburgers, and we're sorry about that. And maybe they won't give me a refund, maybe they will. If I then have to go to another hamburger joint in order to get the remaining 50 hamburgers, but I have to also pay probably about $1 more per hamburger. Am I not entitled to the extra $50? $1 times 50 more hamburgers that I otherwise would not have been forced to pay, but for the breach of the contract by the first hamburger restaurant? The answer is yes. That would put me back in the place I would have been but for the breach. Page 149, another extraordinarily important concept of contract law. If I was, again, going to make that pantheon, that the top 5 concepts that you should know in contract law, another one, I remember the first time, last chapter, it was promissory estoppel. This time it's the parole evidence rule. Bottom of page 149. Contracts, so you know, can take 3 possible forms. They can be entirely oral, they can be entirely written, and they can be both oral and written. All right? The parole evidence rule, which you'll see on page 150 how it's defined, it's a rule that limits the evidence a party can introduce in court concerning the contents of a contract. There are certain types of contracts or certain types of language in contracts that cannot be oral, that it has to be in written form. And if it is oral, then the court's not going to allow for it to be admitted into evidence. For purposes of what we've been discussing so far, if you go back a couple of pages, you'll notice that there is this notion of the entire contract clause. The entire contract clause is a critical clause. It may be the most boilerplate clause in the entire contract, as I said earlier, but yet it sort of says, it establishes, this is the contract. There's nothing outside of this contract that can possibly exist if a court's going to be called upon to interpret a contract, or if the parties are going to attempt to figure out what they're supposed to do under the terms of the contract, they have to stick within the 4 corners of the contract. They can't rely then upon other types of oral agreements or other oral comments or oral understandings. And that's essentially what the parole evidence rule is also trying to do. It's trying to limit, especially in certain specific contexts, when an oral communication or an oral agreement can come into court as evidence. Now, the parole evidence rule is by far not perfect. And as we'll learn with, again, maybe the third concept, which we haven't touched on yet, which is called the statute of frauds. Having things down in writing is extremely important, but reasonably speaking, not everything is going to be in the written contract. And you want to be able to have that context in order to be able to help provide understanding of what the parties were feeling and what may be a reasonable outcome. If you go to the bottom of page 150, you'll see at least 4 different reasons why oral evidence is important when determining the effects of a particular contractual arrangement. You'll see there, if there is an alleged problem going to the formation of the contract, because one party alleges fraud, that may be something where the court would want to hear that type of evidence, and that arguably should not be prohibited by the parole evidence rule. If the contract is intended to be partly oral and partly in writing, the rule, just so you know, has no application. If there is an intention by the parties that part of this be oral, part of it be written, the parole evidence rule will not be enforced. If the promise to be enforced is contained in a separate agreement that happens to be oral, the rule does not apply as well. And if the language in the contract is ambiguous, evidence outside the written contract can be used to resolve the ambiguity. So the parole evidence rule, although it is an important rule, there is going to have to be flexibility accorded to it, especially in the last example when you're dealing with vague or ambiguous language within the actual contract itself. If you'll note, please, Corey Developments on page 151. It demonstrates how an entire contract clause that we've been talking about may not prevent a court from considering parole evidence. It gives you a good example of how parole evidence has no place in that particular context. You'll also note on page 152 evidence of electronic contracts and how that could be admitted under Canada's Evidence Act. We move on to page 154 and we deal with this notion of conditional agreements. Now, the notion of conditional agreements should be something that you can understand. In order for there to be an agreement, certain conditions have to be met. You'll see two different definitions on the left-hand bar, page 154. A condition subsequent, which is defined as an event or circumstances that, when it occurs, brings an existing contract to an end, and a condition precedent, an event or circumstance that, until it occurs, suspends the party's obligations to perform under the contract. A great example of a condition subsequent may be that the elements of the contract have been fulfilled. Or here, right here in the middle of the page, parties to an employment contract may agree that an employee is to work for an organization unless the employee's sales drop below a certain amount. That is a condition subsequent, meaning the company no longer has to keep the employee. There is no agreement to keep the employee as an employee once his or her sales fall below a certain amount. At that point, the company has the ability to simply terminate the contract. The contract just comes to an end. A condition subsequent has actually occurred. A condition precedent makes it so that before the contract becomes effective, certain things have got to happen. They give you an example. In a real estate situation, a court would imply a term that the vendor, the seller, must wait until the time for fulfilling the condition has passed before it can sell to someone else. It's a condition before the contract can actually be effective. You'll notice certain examples here when it comes down to real estate on the top of page 155. How can you purchase real estate? Especially if it's for a different purpose. Say that you can't have particular real estate in a particular area because, say you want to establish a store, and yet at the present time that store is in an area which is zoned not for commercial but only for residential homes. Before you can actually purchase that property, then the land needs to be rezoned. A good condition precedent to the sale would be that the seller, the vendor, actually applies to have the land rezoned in a way which would allow for some type of commercial use. You can see other types of examples as well. One of the big ones in real estate law is mortgage financing. If you're going to sell a home, or if you're going to rather purchase a home, no one's going to sell you a home until they can establish that you have achieved mortgage financing. Unless you can pay all up front the entire amount, which some people, I guess, are fortunate to be able to do, but most are not. The only way that somebody's going to sell you their home is if you have a bank backing you up so that the amount that you've asked for your home is going to be paid entirely before the time of closing. And the ability of somebody who's buying a home to achieve financing is going to be an important condition precedent to the entire real estate deal going forward. In fact, there's no point in doing all the other stuff associated with selling a home until you can actually establish that the buyer has financing to buy the home. All right, a couple of other important provisions that you find within a written contract are mentioned on page 156. Limitation of liability clause, and then an exemption clause. Limitation of liability, it's pretty self-explanatory. It limits the amount of liability that one party could owe to the other. That's essentially it. It may cap the liability at a certain amount. So say that Trackers violates its obligations to Coasters. What is the limitation of liability? Trackers may have something in there that limits liability to 1/2 of Coaster's ultimate loss. But if that's in there, then Trackers cannot be held liable for any more than that specific limitation of liability. Similarly, an exemption clause would exempt would exclude one party from liability or both parties from liability to the other under certain circumstances. We also come down to, on page 159, this notion of liquidated damages. Liquidated damages deal with it's a clause that deals specifically with what happens in terms of a breach. What the other side, who is the breaching side of a contract, is going to have to pay to the non-breaching side, the victim of the breach. Liquidated damages could be established in a set amount, or it could be set by various types of categories. Liquidated damages could also include the costs of having to enforce the actual breach, meaning that the breaching side may and normally has to pay the legal fees to the non-breaching side. There's also this notion of a penalty clause that's mentioned in passing on page 160. So, we deal with business law and practice revisited on pages 160 to 161, and we go right back to the hypothetical involved with trackers and coasters. Guys, please review that carefully because it will help to give you a much better understanding of all the minutiae, all the nitty-gritty behind many of the terms of their particular contractual relationship, and it helps to put things into much better context for you in a real life styled example. On to chapter 8.